structured if we are going to be able to make a difference going forward. Can you still hear me?
Yes, I can hear you. Okay. You know, both of us are in Zoom. I can.
Thank you very much, Prof. The major reason why methods of legal education are constantly changing is the need to reconcile the aim of teaching law as one of the many academic disciplines with its goal of preparing persons to become members of the legal profession. And this is an issue that has been restated severally today by different speakers. It is my own view that where legal education is properly structured and delivered, it must be able to produce lawyers that will, one, add value and positively impact their surroundings, local, national, and global. Two, the lawyers must be able to relate with the intentions, actions, and feelings of others, be it superiors and subordinates, with the primary goal of achieving what is just and fair. And thirdly, the lawyers themselves must be able to anticipate the short and long-term consequences of their own act and omission. All of us will not deny the fact that that is far from where we ought to be as we are today. I will give two examples to buttress my position. I will make reference to a matter that I am handling with another learned silk. It's a land matter. When we got information about that land, the first thing I did, this was 6 months before they went to court. I said, we will appoint a surveyor. You will appoint a surveyor through your client, and the two of them will meet and do a composite plan. This is the kind of thing that the court will ask us to do. For 6 months, my colleague did not accede to that request until the matter eventually was filed in court. And I told him, if we have done this, this matter may not have ended up in court because we will know where there is an overlap in the matter, in the land of the respective parties, and we will be able to resolve it. You will earn your fees, I will earn my fees, and all of us will not go into the courtroom and the clients will be satisfied. It did not happen. A second one, I am involved in another matter with another silk who hid authorities that should be cited before the court. He was involved in the matter in fact, he was involved in that matter in Ondo State. And at the end of the day, when the Court of Appeal gave a decision in respect of the matter, can you still hear me? Okay. When the Court of Appeal gave a decision in that matter, all his arguments were overruled. We were now involved in a similar matter with him in Lagos. The same argument verbatim he brought before the court. We stumbled on the authority of that matter relating to the Court of Appeal. He never brought it before the court. Why am I citing this? Just to show that aberration in legal practice is very prevalent at the top. What are younger ones going to learn at the end of the day if we continue along this line? At the 2021 Olanipekun Justice Summit, where I gave the keynote address on implementing justice sector reforms in Nigeria, I made the point that we can tick all the boxes in reforms, but the impact is not being felt within the society. And for as long as the impact is not being felt, we, that is, we the practitioners, we will remain endangered species who will not be respected by the system. And at the end of the day, even the justice system will be nothing more than a laughingstock for people. When you look at the World, the Justice Project, the World Justice Project Rule of Law Index for 2021, Nigeria ranked 121 out of 139 countries. Within the sub-Saharan region, Nigeria ranked 26 out of 33 countries. At the end of the day, this is the state of our justice system. And I say, it is what is coming out through legal education that we are witnessing in the way practice is being done. In the area, now I come to assessment of university law programs, and then I will do that of the law school. In the area of pedagogical reforms, and I'm so glad that a number of discussants and speakers have spoken about this today. My assessment is that a number of our universities are still struggling. We have situations where colleagues are still dictating notes in classrooms. We have situations where colleagues do not recognize that you need to give your lecture materials to students at the beginning of the semester so that they will come to class and engage with you. But we still go ahead, continue to regurgitate some of the things that we did during our own time. That is what we are pushing to them, forgetting the fact that the dynamics of it has changed. While I will not deny that there are pockets of best practices, a huge number of colleagues are still engaged in an instructional methodology and teaching learning approach that cannot achieve effectual legal education. So there is an urgent need, as previous speakers have also argued, for us to design, develop, and validate training guides that will incorporate techniques that offer constructivist, collaborative, integrative, reflective, and inquiry-based learning within our system. In the area of curricular reforms for the universities, I am aware that the National Universities Commission recently concluded a comprehensive review of the curriculum of Nigerian universities, inclusive of that of the law discipline. I was a part of that process. I want to say that that process involved the participation of all stakeholders. The document in its overview, the philosophy, the objectives, unique features, expectation on employability, and 21st century skills capture the characteristics that one will expect to find in the content and topic and process design of a 21st century law curriculum. But that is not to say the fact that you have a good curriculum will not in itself translate into future lawyers that are amazing and awesome, the kind of thing that the society wants. The way it is being taught will depend on what the teachers are able to put forward. And that is why I'm so happy that previous speakers, particularly the last session that I was opportune to listen to, they stressed on this and emphasized the importance of good pedagogy in terms of relating with our students. Some of the threatening issues to which emphasis have now been given in the revised curriculum are ethics in legal education, legal clinics, problem solving and analytical skills, pro bono work, entrepreneurship, transactional skills, and social engineering. My expectation will be that when that document is eventually adopted, a body like the NBA should, going forward, work in conjunction with the Council of Legal Education and also possibly with the National Association of Nigerian Law Teachers to have in place a mechanism for monitoring and evaluation, and technology can avail us the opportunity of evaluation. Let me now go to the law school, my assessment of the Nigerian Law School. Beginning in 2008, the Nigerian Law School adopted an interactive approach to learning. This entails the school front-loading topics and curriculum to the students, who are expected to study these topics, have an understanding of it, and discuss same as the next lecture, when the lecturer and members of their duly assigned groups will sit together to discuss it. This approach, I will say, is laudable in that it enables students to become more engaged with the subject. It sharpens their critical thinking skills, and it helps them to develop analytic reasoning. For the period of almost 14 years that this approach has been running, my questions are, what feedback do we have from monitoring and evaluation? What routinized inspection currently exists to determine how well learning has been occurring? Now, I interacted with a number of fresh graduates, and they noted that lecturers at the law school routinely canvass strict adherence to law school marking schemes in ways that stifle students' creativity. They also made comments about insufficient time to fully assimilate bulky reading materials before having to prepare for the next topic. But more fundamental to me, because those ones may neither be here nor there, more fundamental to me is that a number of young practitioners with hindsight of 1 or 2 years of practice have noted the need for the law school to expand and increase the opportunity for experiential learning through more of court and law firm attachment, externships, simulation-based courses, and clinical programs that can make them more practice ready. And one of the things that I think the law school needs to do, if they have not done it yet, they need to conduct an empirical study, empirical survey of how has their practice approach, their teaching approach, how has it succeeded in bringing out the kind of lawyer that we expect for the 21st century? One will not be mistaken to hold the view that the procedural aspects of the law taught at the law school will barely achieve their objectives without sufficient actual experience of the law in practice. And for me, I think these practical aspects should take up close to 50% of the time that is being spent in the law school. Again, I believe the MBA, in conjunction with the Council of Legal Education, must be interested in the concerns I've raised, in the kind of empirical study that must happen, because the reality of building sustainable and competitive legal enterprise that can dominate the new market for legal services require that we go beyond requisite knowledge needed to merely pass the bar final exams, but also inculcating in future lawyers a culture of recognizing in themselves and seeing in themselves problem solvers and solution providers, whose goal will be to engineer socially desirable results. Now, I have shared a table in my paper where I indicated some of what we must have in a pedagogical fine-tuned scheme that will deliver. I will not bother to go through it since that material will be circulated. Again, I have also shown in terms of curriculum reforms, what we should be looking at if we want to have a robust curriculum for the 21st century. It must be interdisciplinary. It must engage all the things that the previous speakers have spoken about. I align myself with the views of these earlier speakers. In the paper that I share, in terms of that table, I argued again that what we must be looking at this moment is an integrated pedagogy. And I believe that the MBA can work with the Council of Legal Education and a more vibrant Nigerian Association of Law Teachers to come up with a toolkit that can be used to train our trainers. And this can be done using technology. Now, our universities and law schools must also be actively encouraged and monitored to integrate standard practice of quarterly lectures, organized in the form of panel discussions, to bring in talented practitioners or other professionals to discuss issues that are driving today's society. For me, if a practitioner comes into the class and spends 2 hours with the students, it may take what 2 weeks of lectures can cover at times, because he's going to be sharing with them practical experience and talking about challenges that he faced in practice. Some of the things that I believe will also cut across that students, law students must be interested in now, issues relating to cybersecurity, process management, litigation management, quantitative analysis, entrepreneurship. That is the business and market of law, not just because you want to be in the profession, but realize that you are in business. Process and metrics of sound decision-making, both in the legal and non-legal setting, advances in technology and business model innovation. These are the kind of things that should be of interest to lawyers that we are beginning to churn out. And also for some of those who are already in practice. Given the ease of data gathering today, I noted that performance tracking for our faculties of law and the law school should not be difficult if at the end of the day, we sit together and think through the mechanisms that we want to utilize. Let me now quickly go to lawyers in practice. It is my view that it is not only the future lawyers that is faced by disruptions caused by advances in technology. Lawyers in practice are also contending with increased scope of legal practice and a global legal practice that is driven by technology. All the previous speakers emphasized this point, and we must not lose sight of it. All of these have altered the competition in the industry for clients. For the practicing lawyer, it is my view that substantial amount of unlearning and relearning must come up if they are going to be able to succeed and make, if they are going to be able to make a life of successful legal practice. Again, as our earlier speakers mentioned, continuing professional development is key in achieving this. Now, when you look at rules 11 and 12 of our rules of professional conduct, unless a legal practitioner holds an annual practicing certificate issued by the MBA, certifying that he has fulfilled the approved CPD programs, he is prohibited from carrying on legal practice. But what is evident to all of us is that achieving compliance with rules 11 and 12 will be a challenge at this point in time. Indeed, if we push for its enforcement, it's likely to spoil a debate that will further distract and divide us. A number of colleagues, particularly our younger colleagues, are struggling to survive. So before I push for what I think should be an adaptive strategy, I must really commend the MBA Institute of Continuing Legal Education for its activities in recent years. Through the several online and the physical training workshops, seminars, lectures that they have been throwing up in cutting-edge areas, they have been able to assist quite a number of practitioners. Now, if I go back to what I see as the strategies for upskilling, the upskilling of lawyers, rather than chasing, my own view is that rather than chasing the CPDRs as metric for CPD, we should begin to look at a jurisdiction like the United Kingdom, where they are using the outcome-focused CPD model. They introduced this in November 2016. And what they are looking at is a situation where law firms, legal practitioners will develop bespoke CPD programs that allow the lawyers and lawyers in the law firms to reflect on the quality of their practice, identify any learning and development needs. So rather than imposing a common CPD appraisal metric for all lawyers, we can look at a situation where each law firm will develop CPD programs tailored to meet their needs, the needs of their lawyers, firms and clients. Quite a number of law firms are already doing this, and afford them the flexibility to address their needs. I state that the MBA, working with using the SRA template, can develop a guidance note that provides useful information and resources to help law firms and practitioners to adapt to this new approach. What are the key components? They want to be able to reflect on their practice. They want to be able to identify and plan their learning needs and development. They want to be able to address these learning needs and development through programs prepared by them and delivered for them. They want to be able to record and evaluate what they have done. And they want to be able to report compliance back to the MBA. The way the solicitors have done it in the UK, the Bar Standard Board in January of 2017 introduced a similar outcome-focused CPD scheme for baristas. And this is what I think we should be looking at. The above approach, I say, should serve to complement the current efforts of the MBA ICNE. So it is not that the continuing legal education of MBA will stop their own activities. They will continue that activity. They will continue to put on board these robust programs that they are doing. But at the end of the day, they give opportunity to law firms to also develop what they want. Again, I'm suggesting that MBA should be looking at what kind of encouragement or inducement can you give to law firms who throw open their doors to lawyers who are probably just budding lawyers to come in and be part of their training programs in their law firms. Because at the end of the day, when things like this happen, so many others will be able to benefit from it. Again, I noted that the MBA should also be interested in innovative partnerships with faculties of law so that they can develop bespoke LLM and certificate programs that allows for online learning modules and for which brilliant young practitioners can have partial support, scholarship support from the MBA. Finally, we must not relent in thinking through how to introduce compulsory pupillage of between 6 months to 1 year that will have appropriately guaranteed earnings attached to it. I know that has been tried before, but I think we should go back and revisit it. We need to have a situation where young lawyers just coming out of the law school are able to have pupillage for 6 months, and they are properly paid, not used as slaves, such that they can take on some of the ethics of the profession as desired. What is my conclusion? I say that the challenges of Nigeria are huge. Many are overwhelmed, and they also think that these are intractable. I do not agree that the situation is out of control. If we get the administration of justice system right in Nigeria, such that there is accountability, Nigeria will be on the path to recovery. At the moment, the legal profession is in crisis. If we are to make a difference to our justice system, then the way we upskill legal practitioners and train future lawyers must be so that they are able to respond to substantive issues of justice, client needs, and market conditions. Let me also commend the president and members of his team for what you started off not too long ago in terms of disciplinary measures for those who are guilty of professional misconduct. All of the reforms that we are talking about, none of them will achieve anything without discipline. And that is why I am hoping and praying that the petitions that you have submitted, the processes that you have started, those who are going to succeed you will not go on the politics of soft landing, because that is what happens a lot in this country. People beg through violations. People beg through offenses. And when they do that, there is no way you can maintain standards. I want to thank Mr. President. I want to thank the distinguished audience for the opportunity to engage with this team. I thank you very much.
Well, thank you very much, Leonard Essien. We've listened or attempted to listen to what the Leonard Silk has presented. I don't know from the other side, but from here, it wasn't quite very clear. The IT, there's a few issues with the audibility of the system, but largely the paper he presented is here. And he started by putting forward a jurisprudential and philosophical understanding of what legal education is all about and what it should be able to achieve, and the perspectives generally of the concept of legal education. And of course, he also presented what he calls stages of growth and development of legal education, and identified what he considers to be milestones which must be delivered for a legal education to achieve its objectives. Prof also identified the problems associated with the Nigerian legal system, many of them, chief of which is inefficiencies of the system and what needs to be done to improve or change the tide. In identifying strategies, he started with the structure of the university law programs across all faculties and colleges of law, where he presented an appraisal and a background of how the system is at the moment. And he brought out very good, profound suggestions on what he believes will help in terms of tampering with both the curriculum and the methods. Because from his paper, you will see clearly that he has been able to separate these two issues. There's a difference between the methodology and a difference between the content. The content has to do with the curriculum. And both of them require to be tempered with, both of them require to be reformed. Prof also assessed the Nigerian law school and what he believes should be done in order to improve on the mandate delivery of the law school. He went on to say that it will not be mistaken to hold the view that the procedural aspects of law taught at law school will barely achieve the objectives without sufficient actual experience of law in practice by the students by way of creation of additional time for courts. And therefore, he suggested that more time need to be accorded to practical training of law schools, yes. Yes. Oh, okay, sure. Okay. If everybody heard very clearly, then there's no need for me to continue to summarize the paper. If that's the case, I think we'll go to the next. By what I have here, the next speaker will be the learned Honorable Attorney General of Oyo State, Professor Olo Oyo, SN, my boss. Professor Oyo was the Dean of the Faculty of Law, University of Lagos. Incidentally, at the time he was the Dean of Lagos, I was Dean of the Faculty of Law, University of Kefi. And we worked very closely together while I made all effort to learn from him. And now he's Attorney General of Oyo State, and I'm Attorney General of Nasarawa State. I'm also trying to learn a lot from him. Thank you, my mentor. Please go ahead and present your paper, sir.
And I can tell you for free that he's going to be on the next list of senior advocates of Nigeria. Thank you very much. First, let me appreciate the organizers. A lot have been said, but I think it bears repeating that what they are doing is what is needed. Let me also appreciate the setting for this particular gathering, which is the Afe Babalola University, which epitomizes the best example of private university education and legal education and education in Nigeria. Now, the topic we have is to similarly cascade all that has been discussed and for us to kind of come up with a future of legal education. And that's like looking into a crystal ball to predict the future. Who knows what the future will be? But basically, I always adopt the approach of T.S. Eliot to look at time within time past, time present, and time future, time being always continuous. When we look at this house, the question we ask ourselves, can we mend this house? Or should we pull down this house? When you look at the resources and the costs that we have for legal education, the idea of pulling down the house may be more difficult to achieve, to start afresh. That is even not our approach. So that is why the topic, adaptive strategies for the future of legal education in Nigeria. When my learned friend and brother, my learned brother Silk and the former Vice Chancellor was presenting, he was on point in the observations he made about the law school, about the faculties of law, continuing legal education and all that. But my approach is to look at the topic as one that gives me a fresh cloth. And I ask myself, should I put a new wine in an old wineskin? And I don't think that will be the approach. So the critical appraisal that I would do is to first ask the question, what is the objective of legal education in Nigeria? Bearing in mind the origins of legal education as a colonial conception to feed the colonial apparatus. So basically now, post-colonial, what should be the kind of lawyer that we produce? Is it the kind of lawyer that is just going to be having the knowledge of the laws and then he waits to go to the law school to have some knowledge of practice and goes through life guessing at what comes his way? And the answer is no. Why? Because we have seen other people do it better. And when I make my examples, I don't go outside the African continent. One of the beauties of legal education in Africa is that in some areas, we have met each other. In fact, one of the programs we used to have from University of Pretoria, the African Moot Court Competition, which brought all of us together, gave us the opportunity to benchmark ourselves and test ourselves and know the standard of our education, both in terms of pedagogy or whatever you want to say, or whatever methodology you want to use. The end product is that we are about lawyering. We are not producing a law graduate. We are to produce a lawyer. And once you come to that destination, you know that the production of a lawyer is not about teaching him some subjects, but are equipping him with lawyering skills. And that you never hear in our curriculum. If you are not equipped with skills, you can't demonstrate them. And actually, we just produce half-baked something, hoping for the completion of the product when it gets out. Meanwhile, the person that wants to use the product is expecting you to produce a complete product. But the philosophy and the idea behind our legal education is to produce half-baked products. And I'm speaking from my personal experience. Because even rudimentary things that could be taken for granted, like the books case, skills that you are not taught in the law school, you only acquire them when you get on the field. And the joke of it is that on the field, I'm expected to come equipped with the skills. So there is a dislocation or a disconnect between the conception of legal education and the end product for which legal education is to be used. Now, when you are in an environment like this, you say, a problem once known is half solved. Is that not so? But I assume that this is Nigeria. A problem once known is not to be solved. At least you know that that problem is there. And that's the Austrian approach that we have taken. If we must be bold, we must attack the problem from its roots. We must attack the structure or the superstructure upon which our legal education is built. It is totally obsolete, archaic, needs to be discarded, and needs to be reformulated. And that takes me even to the subtopics of, maintaining standards and monitoring and evaluating and all that. It's not very hard for you to know that there is something wrong with our structures, because even with all the imperfection, to borrow from the song that we heard, when this product gets to a different climate, it performs. So, which means we need to do something. A lot have been said, which I will not bother to repeat, about in terms of standard has to be set across board, not only for students, but also for us, the teachers. Because teaching, there's always a question. Are teachers born or are teachers made? It's a product of the two. Even if you're a born teacher, if you don't improve on it, you'll fall flat. So basically, when we acquire the certificate and present ourselves as teachers, actually, we are not yet teachers. And we just mimic. For me, like Professor Ojukwu, my learned brother, said, when I stood in front of students, I closed my eyes. I saw my bad students, my bad lecturers. I put them to this side. I saw my good lecturers. I put them to this side. And I always put that memory before me when I go before the student. I don't want to be a bad lecturer. So what were the bad lecturers doing? And what were the good lecturers doing? So we need to find out among our teachers, the teachers that are doing good, from even among universities. And that is also a function of the Nigerian Association of Law Teachers. We must be humble enough to know that that association is not just a gathering for presentation of paper of this parish, public or parish. We must have opportunity to, question ourselves. Are we still doing well? And that is as to the standards. Then in terms of the Nigerian Law School, a lot have been said. I belong to that school of thought that this bifurcation or dichotomy has gone off long enough. for the simple reason that I've seen it from this environment, and I've also seen it from another environment. I happen to have been, blessed by being a Fulbright scholar at UCLA, and from there I decided to sit for the American bar from a Commonwealth jurisdiction. I did not go to any law school. When I saw the questions that were to be asked, nobody told me. I enrolled with bar passers, and bar passers took me through the process. As a matter of fact, the first mock exam they did precipitated my giving out my television to somebody, because I just thought that, look, this exam and my television, they don't go together. Because I was a Nigerian who went from NTA to a 50-channel, DSTV pass something. So of course I'll have the book. I'll say, okay, let me even rest and, energize myself with this, and before you know it, I'm lost. So I had to give out my telly. So there are sacrifices to be made. Then in terms of the end user, seriously, I have harsh words for the Nigerian Bar Association and the leadership thereof. They are sponges. They sponge off the efforts of law teachers. The best law firms do not contribute anything to legal education in Nigeria. They wait outside the doors of the university. I have been dean. Asking for money from a lawyer is worse than pulling his tooth. Very few lawyers are generous with what they benefit from the profession. They will buy exotic cars. One money for one Rolls Royce or for one Jeep can do interactive something in your former university. When was the last time you went to Ife or came to University of Lagos? We need interactive boards. How much is one interactive board? Your lunch and your dinner can pay for something that will improve the community you left behind. And when they say greatest of the greatest, that's a joke. You should shut up. The truth of the matter is that we are engaged in a blaming game. We need to be truthful. Which particular blame concerns you, take it up. The profession has done nothing. Over the years, we have produced thousands of lawyers that have been great. But what has the profession given back? And I'm saying this from experience. I went to UCLA in where was there? I've forgotten which year, 1989 to 1990. Then I went back there in 2014 to collect my certificate because I just thought I was in the town, let me collect it. I stood in front of the same faculty, School of Law, and I was asking for direction. Why? When I was there, it was a 4-story building. And I was standing in front of a 12-story building, School of Law. Nothing of the old was left. If I go to Ife, I can't miss my way. My faculty, I know it. Nothing has changed. Come to Unilag. The only thing you see, we put 1-story building after 1960 Bangan. It's a shame. We need to tell ourselves the truth. So bottom line, across the spectrum, we need to have a paradigm shift. And government must make up its mind. Do you want to have quality legal education? Or you want to be doing some politics with setting up law school in Oyekiti, one in Damaturu, in one in... That's not what this profession is law about. So bottom line, even in terms of government must be ready to play the role, to invest. We are in a private university. See this environment. How many federal universities can boast of facilities like this? In rounding up, I believe if the truth be told, if we continue the same way we have and expect change, the answer is that of Einstein. We must be fools. And I don't think we are fools in this country. Thank you very much.
Thank you very much, Leonard SN. Professor Yo, the Honorable Attorney General of Oyo State. It was a very brief but incisive presentation. He took his time to speak to the issues, but at the same time also advocated to practitioners to pay attention to their alma mater, identifying that the way forward is not for the proprietors to be left alone to cater for the institutions, but for former students to also show interest, especially practitioners. I think that's the only way out. But at the same time, for those who are managing the institutions, pay more attention to their work and sacrifice more of their time. And I remember when I became the dean of the faculty in Kefi, and the condition the faculty was in fact, it has lost accreditation at that moment, and we needed to turn things around. I had to abandon my private practice to be in the faculty almost 24/7 to ensure everything is put in place. At some point, when we discovered that when we put new things in the classrooms, projectors, interactive boards, fix the chairs, before the next morning they're vandalized again by students who claim to come to read at night, I started keeping the keys to the classrooms in my pocket. And I think this is one area which public universities are seriously lacking: thorough and proper supervision. Mostly public universities lack that. I think that's what private universities also enjoy. The fact that it is somebody's property, he is always there to ensure that his asset is well protected. But nobody takes ownership of what belongs to the public. And I think for us, practitioners and administrators of law schools and faculties, we need to act differently. I would call someone whom you have all heard about, probably never seen. You've all felt about who he is, read his books, never probably encountered him physically. Professor Kasim Momodu is a veteran. You begin to wonder what he's still doing in the system. The same sacrifice we talk about. He's a professor from the past, professor of the present. He's a great-grand lecturer, lecturer of lecturers, professor of professors. Professor Momodu is an authority in insurance law. He was an executive in Chevron. He's one of the foremost experts also in oil and gas law in Nigeria. Prof, you are welcome, sir. He's presently assisting to be the dean, because I'm saying he's assistant dean of the Faculty of Law, Crescent University. Thank you very much, Prof. Please can go ahead, sir.
Thank you very much. I'm beginning to wonder whether you're talking about myself or somebody I know. Thank you very much for the compliments. I'm glad to be here, and when I was elected to be a member of the committee, I never thought I'll be talking to an audience. I thought I'll just be part of those who are organizing events like this, but it's a pleasure to be here. And I've had the privilege of reading the paper Professor presented long before now. And I also had the privilege of going through some of the papers Professor Ojukwu sent to our committee. And I had a reflection on what the situation was when I was a student from 1974, and when the university campuses were made up of students from all over the world. In my class in 1974, we had students from Canada, we had some students from India, we had students from Commonwealth. Commonwealth scholarships were given to Nigerians to go abroad to Commonwealth countries. Commonwealth scholars also came to Nigeria. Then the academic staff was also international. We had staff from all over. I had lecturers from Harvard who were on sabbatical teaching me. We had some from the UK, some from India, Pakistan. Professor Nwabweze taught me constitutional law, but he did not come in as a Nigerian, he came in as a British from the University College London at that time. So when I heard Professor Juku talked about his experience in Ife, I wondered, I said, wait a minute, is it that after we left, the whole system deteriorated to the level he was talking about? Because my own experience as a student was far different from that. We had a wonderful time, both in terms of your classmates, in terms of the faculty, and in terms of everything to do with education in Nigeria at that time. That was in the 70s. And even when I started teaching in the university in 1980, University of Lagos, each time we went for Law Teachers Conference, it was an international gathering of lecturers. International gathering of lecturers. And I saw the system grow from just 6 faculties of law to 8, 10. By the time we were growing, I do recall in 1982, the Law Teachers Conference in Maiduguri, Nikitobi of blessed memory, he was the Dean of Law in Maiduguri. We had deans from different countries, from different universities. Gateba in Calabar at that time. And there was this discussion of regulation of legal education, because at that time, the faculties were increasing. So the issues we're discussing today were even discussed at that time. Situation was not as bad as it is today, but even at that time, it was realized that the structures in place for regulation of legal education needed to change, needed to be improved. So that is why today my reaction is going to be on the structures, on the structure for regulating legal education. Again, I'll say thank you to Professor Ojukwu for telling us how the law school works, how the Council of Legal Education works. Of course, it confirms what has always been my view about how it works. It also reinforces my views as to the recommendations I intend to make. In other words, the problem we have with all these strategies and implementation of strategies really has to do with no structure at all in place for monitoring and for regulating the legal education. None. Yes, you can talk of the Council of Legal Education. Of what use is the Council of Legal Education? If it is just the DG of the law school and the Director of Administration of the law school that handle everything to do with accreditation. And all the Council of Legal Education does is to ratify whatever it brought to it. Is that not the scenario? And that is what we discussed in the Law Teachers Conference in 1982. That the way the faculties were growing, there was a need to have a proper structure different from the Nigerian law school that will regulate, monitor quality legal education. Because the system you have now had been like that before Ibironke. I'm not sure how many of you met Ibironke. Ibironke was before Abayomi. Some of you probably met Abayomi. And when I was in the law school, Ibironke was the secretary of the law school before he became DG. Now, what is my recommendation? We need to have recommendations that we can attempt to implement this year. By the time these politicians start politicking again, nobody will think about MBA or recommendation from MBA. After the elections, give them another 2 years before they can look at you. And by the time they want to think of looking at your recommendations, they are preparing for another election. That is the circle. But we need to do something. we must separate, or we must recommend that Nigerian Law School be separated from Council of Legal Education. That is number one. If we do not succeed in pulling the Council of Legal Education from the Nigerian Law School, no matter what recommendations you make, you are wasting your time. And how do you do that? The Council of Legal Education will be structured in such a way that they have their own separate building. They have their own office. The council should have its own executive secretary, probably with the same powers as the executive secretary of Council of Legal Aid Council. It should be an executive secretary. You know what they do? Executive secretary of TED Fund. You know how powerful he is. Council of Legal Education should be a separate body with its own executive secretary, with its own directorates in different areas. The Nigerian Law School should be Nigerian Law School, to be regulated by that council. And in Nigerian Law School, if they will ever be part of a team going on accreditation, cannot be part of the team. They can only be part of the team, not the leader of the team, not the writer of the report. There will be an executive secretary who will play the role that the DG currently plays. They will have a director of administration who will play the role that the secretary of the council, who is the director of admin in the law school, currently plays. By the time you have a structure like that you call the Council of Legal Education, of course, they can still have a chairman. Ngigeyase can still keep his job. His job is not threatened at all, so let him support us. He should be with us. But the law school will be out of it. They'll be like you and any other faculty. And then you can then regulate the law school itself. That is, if we agree that the law school should continue. And then all these suggestions we are making, suggestion professor has made, that we'll be making since yesterday, we can then think of how this Council of Legal Education can go to sleep with them, can go to work with them. Now, what about the composition of the Council of Legal Education? We don't have time. I could have gone in because I have had experience in the United States. I've had experience in the United Kingdom. Well, that is not the issue. We can't go into that. While I was still a lecturer at the University of Lagos, I was part of the USIS International Visitors Program. We were from 18 academics from 18 different countries. And we visited 10 states, courts, and schools. I still have the report from that. So we've seen it. The composition of the Council of Legal Education should include the National Nigerian Association of Law Teachers. As it is today, the Nigerian Association of Law Teachers is not part of the Council of Legal Education. Not even the president. There is one head of a law faculty nominated by the Attorney General, despite the fact that the law itself provides that the head of every recognized law faculty should be a member. I do not even subscribe to the fact that everybody should be there, to be unwilling. But the Nigerian Association of Law Teachers should be able to nominate at least 10 of its members to be in that council. Mr. President, you recall that during your presidential debate, the only question I asked had to do with this issue. I asked the three of them, what will you do when you become president? About the state of the quality of legal education and continuing legal education. Each of them promised to do something about it. I'm glad that, and when he became president, you recall, Mr. President, I wrote you. I wrote Mr. President, I reminded him, and I made my own proposals. I suggested to him, everything I'm saying now, I put in writing at that time. So when he selected, or I don't know whether I was elected or selected or appointed into this committee, I laughed. I said, is the president telling me that all the suggestions you have been making to me, go and do it in that committee? Before that time, I took this matter up with OCJ Okocha when he was chairman of Body of Benchers. I took this matter up with Mahmoud when he was acting chairman of Council of Legal Education and president of the bar. I took it up with your predecessor, Paul Usoro. All these persons, apart from OCJ Okocha, with whom I had a telephone conversation, all others I put in writing, just as I did with you, Mr. President. I'm glad that you have done something. In case of OCJ Okocha made efforts when he was chairman of Council of Legal Education to separate the law school for the council, but the forces were just too powerful for him. So I thank you, Mr. President. You've done something, and I do hope that in spite of the elections that are coming and the fact that you are on your way out, national elections are coming. We don't know who will be the president. We don't know what will happen, but we've started something. And I do hope that this time around, we are going to succeed. It won't be the same as what happened in the 80s and what we've been told by Professor Ojukwu that has been the case. Thank you very much.
Thank you very much, Prof. Professor of Professors, Professor Mahmoud was brilliant as usual. Talking about regulators, Prof. Ngozi, I'm sure she's listening to us from the other end, and myself at the International Association of Law Schools. For nearly 10 years now is what we've been talking about regulating legal education across the globe. But the question that has always come up is who regulates the regulator? But what has been complicated in the case of Nigeria also is that the regulator is also a player. Mm-hmm. And you have suggested, and I think I will agree, that separating the two will go a long way in giving the council the necessary powers to thoroughly and properly regulate and set up the standards as against the situation as it applies today, where the law school is basically the same council. Like, you just can't differentiate. And the day-to-day running of the activities of the council are carried out by the same law school that ought to be regulated itself. And I think Mr. President has heard very well what needs to be done. But I also will highlight an issue that has been going on in NALT. Right from the time that Professor Larinde was the president of NALT, and then I later took over from her, we've been advocating for the inclusion of NALT and law teachers in key decision-making bodies of legal profession, Body of Benchers, MBA NEC, that's, I think that's the NEC, MBA NEC, that law teachers should be included also on the NEC permanently, also on the Body of Benchers permanently. But instead of considering us into NEC and Body of Benchers, it got worse. We lost our place as deans in the Council of Legal Education. In other words, what goes on now in the Council of Legal Education is that our heads are being shaved in our absence. Key decision-making pertaining to us as law professors and law teachers is taken in our absence and expected to be applied on us in a way and manner for which the formative process did not include us. And I think that would be a problem. I will urge the NBA and all those that matter to please do something about it, and very fast. Mr. President, sir, one decision I was taken, and it's quite unfortunate, DG is not here anymore. And the chairman of the council, Leonard S.N. Injia, has also left. In the last meeting of NORTH in Kano, one resolution that we reached is that we will come to you and appeal that deans of law should be reinstated back onto the Council of Legal Education. It enriches deliberations. It gives more quality to the outcome of discussions, as against the present arrangement where private practitioners, mostly donated by you, sir, by the president into the council, deliberate on an issue that some of them have never encountered before. Some of them had nothing to do with law faculties since they left the universities. And they sit and talk about the content, the curriculum, the standards for law faculties. I think we need to revisit the current policy where law deans have been expunged from law faculties. Professor Larinde, I'm really excited. I'm happy you're back. This is my campus. I remember it was here that my faculty was elected to host the NALT, and I was elected president of NALT in 2017. 2016? 2016, it's been a long time. And each time I come here, I feel like I'm in my school. I'm happy to see you too. Thank you very much. I think the next speaker will be our learned brother and friend, the erudite Professor Tubina.
God.
Professors have allocated the professor to you, sir. You're welcome, sir, to make your presentation. Thank you, sir.
Mr. Moderator, thank you for that very unkind introduction. The only claim that I have to being a teacher is that I am a son of teachers. Nothing more than that. Interesting conversations have taken place today, and oftentimes when I participate in summits and conferences, I wonder, as oftentimes people do wonder, what the outcome of it all will be. I felt a bit nostalgic when Professor Momodu was talking about his days in the university. And having grown up in the university myself, I recollect that there were a lot of foreigners, such that even our school song in primary school reflected the presence of many foreigners in Nigeria. And I feel very sad about where the system of education generally in Nigeria is at. I don't think it's peculiar to the legal profession. I think that some of the challenges that we face is because the public school system and even the private school system has gone bad right from primary school to secondary school and to university. Now, I'm going to comment on the paper that has been delivered very eloquently by the erudite professor. But before I do, I think it was instructive what Professor Ojukwu said yesterday when he said that primarily, as professional associations exist for the purpose of education of potential members of that association, and then for continuing professional education or professional development. So in the paper that was presented, a lot of issues were considered: funding, pedagogy, curriculum, training systems, continuing professional development, standards and regulations. And I will make my comments based on this. Now, whatever we say about it, funding is a big issue, whether it's at the university level, at the law school level, or even post-qualification. So, and when I talk about post-qualification, I talk about continuing professional development, for instance. So, as a policy of the MBA, how much of the revenue of the MBA goes into professional development of its members? It's a big issue. And as far as education and development is concerned, we must think critically about funding. From a personal perspective, I don't care how the funding comes, whether it comes from students paying or lawyers paying, or whether the government funds it or whether NGOs fund it. The bottom line is that there's the realization that there's a funding deficit, and we must think of what standard we want maintained, and then the corollary, which will be funding it. And he talked about teaching pedagogy, and I think a lot has also been said about it by various people. But again, that is also, that has to do with funding again, and approach. So the issue of class sizes is something that we must look at. Tutorial sizes and all of that before even we get to the second part. Whether we like it or not, we have to deal with it. And by the way, I must mention that whenever the MBA is involved, I try to ask myself, what exactly is the MBA there to do? What exactly can we do? And I think that a fundamental approach will be to say to ourselves that these are the ones that are within our remit. These are the ones we don't need a third party to do. And then we start doing it immediately. Prof had asked at the last session what all of this will amount to. And I will say from my perspective that the least that it can amount to is that the MBA actually has a legal education policy, something that defines its position in any conversation around legal education. We can't just say nothing about anything. So if we're able to get to a consensus, and those that represent us in different bodies, including the Council of Legal Education, have a remit within which they operate, and that the everyday Nigerian lawyer knows that this is the position of the MBA on legal education, then at least we have a starting point. Now, a lot of interesting points, but I think one of the worst things that I experienced in my life was the number of times education policy in Nigeria was changed. So when I was in 1987, when I got in secondary school, a certain idea came into play. And it was that they will stop the June-July exam system in universities and introduce the semester system. What that then meant was that we got into secondary school in October. We did what they call a transitional term, right? Which was tantamount to losing a whole year of someone's life. We started, they said you had to do an extra year in secondary school. And then when we got to university, they said you had to do an extra year in university. And I keep asking myself, what is the difference? I mean, the products of today and the products of yesterday, which ones are better? And I definitely think that the products of the past are better. So I think that even in defining where we're going, we must be conscious of what we have to change and only change those things that require changing. Indeed, I think that a lot had been said about the United Kingdom. And I had a 10-year experience working in England. And there were things that I learned. And I think some of those things that I learned define my approach, even in the role that I play today for the MBA. I do not think that it is for nothing that there is a post-education training system in the United Kingdom that requires you, and that was why I asked Kenneth the question I asked him earlier on, and indeed, Prof, that requires a period of pupillage for the barristers 1 year, and a period of training contract, or now whichever contraption you call it, of 24 months to become a solicitor. But I was very excited to hear the comments that Dan Abo made earlier on. And indeed, what Prof had said, that you cannot argue with the fact that there's a requirement for it. But indeed, it's whether we have the structure and enough facility and law firms to actually train people. But I think because it's so fundamental, we have to find a balance between it. And I think that if we talk about externships, I think it's useless, not from the perspective of the documentation around it. That documentation is perfect, like most things. But in its implementation, so you send 30 people to my firm, I accept them. Nobody supervises them. It's a period of time when they spend reading a lot of that. Can we not try something else? Can we not introduce something that means that after their exams, they actually carry out this period of pupillage before they're actually admitted to practice the profession? I think it's something that we must try other than what we have now. Then Interestingly, in looking at the professional development matrix, the learned professor had talked about the provisions of the RPC 2007. Unfortunately, one of the first things that, not the first things, but one of the first things that occurred around the time that Mr. President became president of the NBA was that the Attorney General expunged some provisions of the RPC 2007. And today we're in court over that matter. But I think that it's a bit derelict, and I don't know the full story about it, that between 2007, through the efforts of those who advocated for mandatory continuing legal education in Nigeria, we were still not able to implement it. And the professor in his paper talks about the fact that a lot of our younger colleagues are poor and may not be able to afford continuing legal education. I agree with this. I am an advocate of the welfareist element of training, especially post qualification training. However, it is how we approach it. So for instance, today, and when I looked at the document, the manual around on CPD, I was very excited to see the level of work that Professor Ojukwu and his colleagues at the time had done in that sphere and space. And my advice to the president at the time was that we didn't really need to do anything other than this. The learned professor in his paper suggested that we move to the system that is currently in practice in England. And it's a system that I know too well. It's a system that presumes that you are a responsible practitioner and that you can actually attest to having met the prerequisites of training for the year. I don't think that our polity is matured enough for that. I think that we should start from the point system, as is the case in most parts of the world, and indeed was up till 2016 the case in England. I think that what we need to do is to make sure that the rules that we have already, are implemented to the letter, because as far as I'm concerned, they're very excellent rules. We have to think, I'm told my time is up, but I'll quickly round up. And a corollary to all of this is standards of practice. What I found from older colleagues in practice in Nigeria is that they don't have quite the same willingness to teach. And when we talk about continuing professional development, it's a bit different from the lecturing that we receive from schools or the teaching that we receive from schools, because the emphasis and the focus all over the world is actually on everyday work practice. So the type of faculty we assemble, for instance, is a faculty that is based on peer review of practitioners in the industry. And very quickly before I go, I'll just say that we also need to regulate better, and consequence management is important, because part of the reason why England can move to a system of certify yourself is that negligence is a big issue in England. If you're found not to follow the rules or not to have exercised the level of professional diligence that's required of you, you have to pay the price for it. So I'll just say that I am grateful to the learned professor for the very kind words he said of the works that we're doing at the Institute of Continuing Legal Education. It is work in progress, but I'll say that this is our profession. It belongs to us. We all need to participate to make it better at every level. So whenever we are called, we should answer. Prof, you talked about people who don't go back to their schools. Luckily, my lecturer is about to speak, and she knows I come back often and I spend my money on the school. Thank you very much.
Thank you very much. Like I said, Professor Tobina, even though he said he's not a professor, but he professed very well this evening. He's the chairman of the governing council of the MBA Institute of Continuing Legal Education. And he spoke very well on what needs to be done in terms of instituting the necessary structure that will continue to provide what is required for practitioners, not just for aspiring lawyers, not just for postgraduate system in our universities. So I'm most grateful, sir. The next speaker will be Professor Joy Ngozi Ezeulo, OON. I don't know whether we can have her. She's on Zoom.
Yes, I am.
Professor
I am
Ezeulo,
on. Yes,
OON.
I am.
She's a former dean of the Faculty of Law. Schools. She actually took over from me. Professor Ngozi and myself for many years, I think, we've been representing the country and the continent on the body of the International Association of Law Schools. And she recently took over from me while I have been elevated to the Council of former members of the Board of Governors. Thank you very much. Please, Professor Ezeulo will give you your 10 minutes, between which we expect you round up. So that, but remember, you are the last, but certainly not the least. As well as I know you, I know your presentation will be the best. Thank you.
Thank you. Thank you, moderator. Thank you, distinguished ladies and gentlemen, especially the president of MBA, the lead presenter, Professor Fabuhun, and my fellow panelists. It is really, it's very advantageous sometimes to speak last. The only downside is that probably people you had patiently listened to may not wait and listen to you. And sometimes your time, you could be shortchanged. But I pray and I trust the moderator to make sure that I'm not shortchanged in any way. Thank you. Will agree with me that this is one summit whose time has come, especially given the rapidly changing face of legal education in the midst of evolving domestic and international norms. As the moderator pointed out, we belong to the International Association of Law Schools, and I think I've been a member for long. And in 2013, we hosted even the Global Law Deans Conference in Enugu, which I facilitated. And the International Association of Law Schools, for some time now, have been looking at the global principles that will foreground global legal education. And then when you look at the lead presentation today, we know we live in an era of globalization. So law, and indeed legal education, is unarguably emerging, as it were, from narrow municipal conception and practice to international and transnational discipline. And we must bear that in mind. And then the major pillars that foreground this will be issues around building knowledge, skills, and values. And these are some of the issues that has been examined. I looked at the lead presentation, which we are discussing. I want to thank Professor Larewaju Fabuhun, the former VC and SAN, for doing a wonderful job, because it is a huge task, especially the topic, to effectively look at striking the right balance between, or having interaction or intercourse between what the law, being able to answer the true academic, as a true academic discipline, rigorously theoretical, at the same time sufficiently practical in resolving real life challenge, which was one of the key questions that he addressed. And in looking at that, also discussing what we teach, why we teach that, and how do we teach that, which is the pedagogy that we're all talking about. I think what is fascinating, and I just had in the last few hours opportunity to go and find my paper, which I did in 2014-15. I was then a visiting professor on sabbatical to the Nigeria Institute of Advanced Legal Studies. And in the internal seminar, I decided to focus on setting new agenda and curriculum revision for legal education. And I recall suggesting that they do a summit then that will look either at introducing a more global curriculum in legal education in Nigeria, looking at innovative teaching techniques in enriching the legal education curriculum to prepare students to be a global, for the global career, because that is what we are supposed to be doing. We have to really move and get our students to be globally competitive, to be able to compete in a global market, and respond to the global market demand, as well as be a global citizenship, because we live in the world where the markers of globalization, travel, and consumerism, we're all the same. It's almost all the same. So, and I mentioned the need to set agenda. And some of the topics, I was quite specific. And one of the topics include training lawyers for global competitiveness, the role of Nigerian law schools, faculties of law, and Council of Legal Education, because we have a bifurcated system. And that is also part of the problem we're having. And there's a lot of vested interest that for us to unpack this and then have an honest discussion and decide on if we are structuring, because in adaptive, there are some things that you can't adapt. And there are times that you do patch, it may not work, that we may have to deconstruct and decide to have not just having a new superstructure, but a new architecture that will exactly help us to fashion out how we're going and who will lead this, whether NUC, Council of Legal Education, Nigeria Bar Association. I think in America, and that's why I really commend this very initiative of this current administration in MBA. If you look at the rapidly changing face of legal education, you will find that MBA or American Bar Association, they take a lead in terms of even accreditation of law schools in America. And of course, law schools in the sense we use it is different, because in Nigeria, we have the law faculties, we have the law school, and it's confusing to people. And with regard to that, we still have not been able to really harmonize the curriculum in a way that you can say, the law school, you focus on practice, which should be 70%, not even 50%. And then the rest of the 30 should be on ethics and professional ethics. And then the faculties of law, this is your duty. And even in that, you take Socrates' method of teaching, which is clinical legal education. What I see, going back also to the question, the key question posited by the lead presenter, is that whatever we do, we have to still go back to what is at the core of the learning: knowledge, skills, values. And from our discussion so far, and from what people have said, you will see that the curriculum used in teaching law students is inadequate for the 21st century and ill-suited for preparing students for integration into globalized legal world. Because in dealing with the issue of outmoded curriculum content, and then also the method of teaching, I'm glad that I think it was in UI in 2019, we looked at innovative ways of teaching. And I said, yes, they've taken one of the points I was raising, that we should look at the method, the pedagogy that we're talking about. But still, even at that, the facilities, the infrastructures are lacking in most of the universities. So we should aim, for example, at course content that will accommodate global issues. Here, a distinction needs to be made between merely infusing or cooperating. And that's where, so I may have a little problem with that, the word adaptive. International dimensions, we look at it in the national courses, which we are doing, and introducing new courses of global dimension. For the Chinese, they may be interested in even African customary laws, and then also doing businesses in a way that is also culturally sensitive in Africa. So there is need to promote academic culture in evaluating and encouraging law school teaching and scholarship. And we all agreed with regard to that. And in terms of the problem, yes, the problem is huge. It could be elephant. We know the issue of lack of funding, poor teaching facilities, infrastructure, disruptive electricity supply. There was a time in the university, I recall, they said everybody should use PowerPoint. Then you come to lecture, you're about to project, and then power will be taken. And then what do? If you are prepared all to give by PowerPoint, and then that means you just stop and leave the class. And those were too often. So, but I think I had a better experience than Professor Yelo was saying that lawyers don't give. Really, as the dean of the faculty, I raised, and when I said I raised money, I raised hundreds of millions. I raised over 100 million and did over 66 projects, which part of being an alumni myself, I wanted to reposition the Faculty of Law. I wanted the faculty to be the first and the best. And that is where it is today. It is the first Faculty of Law in Nigeria. It is the best, whether you're looking at the public or private institutions. Never mind the ASU strike, that could be the only downside. But if you look at infrastructure, you will see that we're able to get alumni who donated 10 million to classroom, for example, and then we have the facilities in Bata that people could stay at the lounge and have access to electricity, whether there is a power or not, and prepare their lectures, and that we could have a very enabling environment. So in terms of infrastructure, but that depends on individual effort. And you can't always get the same result everywhere if you had tried. We are happy that we got that, and I'm happy that my successor, where the standards are being kept and everything is being improved upon. But the problem remains funding of education. Today, as we speak, is second month of ASUU strike, and we don't even know where we're headed. And to keep students idle for this long is a danger to the society, not just to their family, but to society in general. And we are talking about standardization of legal education. And we are living in a global world where others are also watching and knowing what is happening also in Nigeria. So we have a real problem. There was a time I checked the funding of education. I think Nigeria scored in UNESCO ranking 136 over 136. And within Africa, I think they were also on the bottom list. And if you look at comparable countries within the West African sub-region or within Africa, like Cote d'Ivoire, like Ghana, or South Africa, Uganda, Nigeria was on the bottom, was just simply a laggard. And if you look at this, you can find immediately the link. But what is rather worrisome, because I don't want to state what is obvious, is the fact that despite the fact that we know we have scarce resources, we've not been able to cut our coat according to our size. We've not been able to tell ourselves a simple truth. Can we continue to run a structure that maintain law school and then have faculties of law? Can we have other models that will work like Professor Oyelwole talked about, going to UCLA and taking the bar exams, as many Nigerians also do benefit without a formal education in the law school? Do we need to talk about making law first degree, or is already with the law school 6 years of one supposed to get a master's? Are we really discussing this? Are we being honest with ourselves? And so I am so happy that we are looking at these issues. But I think there are questions that we must reflect on going forward. What should we reflect in terms of the content of the law we teach? What should be the appropriate pedagogy for law teachers? I believe in evaluation of the teachers themselves. We evaluate students. Of course, the evaluation system is still a very infant stage. But then who will evaluate the teacher? How do we move to use effectively clinical methods to enhance legal research, writing, and advocacy? I want to thank Professor Ernest Ojukwu for the fantastic work he has done in terms of legal education and incorporating a clinical legal education. What should be on the driving seat of who should be on that driving seat for curriculum revision in law? Is this something that MBA should do? I think MBA should, because as has been said by speaker after speaker, you can't be sitting on the seat of regulator and having oversight, and then there is conflict of interest and stuff like that. And we need to have this separated, like the Professor Thomas said. Do we see a common denominator or trend, even in legal education in Africa, for example? What are the peculiar needs of the continent? Because even when we teach, we still have to be cultural, specific in a way in terms of our needs. What do we do with regard to incorporation of African values or ethics? Any prospect of even developing, because we are becoming global citizens. How do we then deal with this issue? I think there is a lot of questions that I may not be able to provide all the answers. But in trying to conclude, because I know the day is fast spent, I want to say that going forward, we are talking of quality assurance, student-teacher relationship better, curriculum, who will take the lead. I've said before that in the US, the American Bar Association take the lead. I don't know how in Nigeria, finally, I mean, they are sitting where they are sitting, but I'm glad that they are beginning to reclaim their mandate, because it should be their mandate as well. We have in Nigeria a bifurcated system that serves different purposes that we have been unable to marry towards our overreaching goal of advancing legal education. The lead speaker's assessment and commendation of law school interactive learning method is what should be happening from year one of their entry into faculties of law. Having requisite capacity to compete will be hinged on the quality of legal education received, which will all be around the knowledge, the skills, and the values. So it is imperative to talk about what we should teach. Why should we teach it? And how do we teach it? So the issue of admission, selection process, evaluation of students, even the recruitment of teachers, because these days jobs are scarce. And you see people who have no business in being lecturers, becoming lecturers, because that's the only job they can find. And they want to have food on their table. With the standard has also gone down, that you might not be surprised to see people with past degrees teaching law, because this is where we are in Nigeria. We need to talk about curriculum review. I recall in our time, they look for the best student and they want to retain you. So I joined right away the faculty. There, I agree, NALT is not positioned well to deliver on its mandate, and they should do far better than what they are doing. Evaluation of the faculty is very key. Infrastructure is the beginning and the end. The MBA Institute of Continuing Legal Education should be part of the standard setting and research in legal education in Nigeria. We should not be deterred by the quantum of the problem. I don't think it's a mission impossible. The difference, I mean, it may be huge, as you know, but we can solve it. But we must have to be honest with ourselves. The lead presenter mentioned about talking to some of the students who graduated, and some of them, their feedback was around expanding and increasing opportunity for experiential learning from court to extension and all of that. And I think that is what we should be doing. I will round up in 1 minute, I'll round up in 1 minute. I think the law degree program that we are running, the law school program, and continuing legal education for practitioners and the bench, and those are the pinnacles of administration of justice. We can look at a model in the Francophone countries. If you are going to become a magistrate or go to the bench, once you enter law school, there is a different stream that you go through. If you're going to be an advocate, a practitioner, there is also a different scene that you go to. I think in the final analysis, we should be considering the vital issues. What knowledge and skills should a law graduate possess? Should all law faculties and law school aspire to offer a global legal education? Who does what and who leads and who should be a driver's seat for, we all gatekeepers, MBA gatekeeper, NALT gatekeeper, NUC gatekeeper, NITES gatekeeper. Who should drive this process so that we can have both a curriculum and we can have the kind of standards set in the legal education in Nigeria that we should all be proud of. Thank you so much. And I'm sorry if I've taken a little more time. Thank you.
Very much. That was an incisive presentation, as expected, bearing your background, experience, your commitment to the growth of our profession, especially the legal education. We are most grateful, we really appreciate. Mr. President, I'm sure you listen very carefully. You will find that in the final analysis, what everyone here has said is that MBA needs to pay more attention to what's going on in legal education. I think that's the whole idea behind this conference. I would, on behalf of the NALT, in my capacity as former president of NALT, and on behalf of all deans, in my capacity as former dean of law, thank you very much, Mr. President, for this. I also must thank the host, our Father Ari, for providing this institution as always. It's not the first time he has done this. For us in the legal teaching profession, we've been here many times, similar engagements, and he will host it all and pay. Professor Damilola, thank you very much for your efforts. The last time we met in Qatar, I don't know whether they have regulator in Qatar, Faculty of Law, but they appear to have everything in the faculty. I don't know whether they impose the standard upon themselves or there's a regulator who regulates them. These are issues for us to ask whether indeed having a regulator will guarantee any form of standard in the first place, or as individuals, We must be able to know our responsibilities and live up to it, especially as professionals. But it's something that I'm sure we'll need to discuss another day. Thank you very much for putting this together. I'm told that we can entertain two questions. I don't know who would, any question? Well, in the absence of any question or contribution or observation, okay. Alaji, you can come. I think there's one person over there.
Right. Thank you so much. Standing on all existing protocols, I would love to pose a question which touches on the thesis of this topic, adaptive strategies. And it takes me back to the initial question I asked in a session, which I believe, with all respect to the learning sake, there was quite a misunderstanding on the objective of that question. And the question touches on basically the assessment structures of the legal education currently in the university level. And why do I think this is important? I think this is important because contemporarily, as a 21st century law student, I think assessment, the level of learning is quite dependent on the level of our assessment. We are prone to learning or studying based on how we are assessed. Now, the question is, I raised initially a diverse assessment systems across the country, across universities. And the question was, based on these diverse systems, how do we unify? I mean, that's quite one of the problems he posed for a school who had an assessment system which was not quite encouraging. How do we unify this assessment system to meet contemporary legal standards? And I would be very practical. What is obtainable in a host of schools is, I want to pass my exams. I just want to cram as much as I can. If the objective to become a successful student is to pass, then I can just want to cram, go to the exam hall and pass, as opposed to learning and understanding to become a better lawyer for the better society. And then you then find 21st century lawyers who, for instance, with a 2-1 degree is not able to meet up with the contemporary standards for the society. So if the assessment system basically for the law school is same, is static, is universal, and the assessment, of course, the competition out there is universal, how do we unify this assessment system? Maybe through a law or through the Council of Legal Education at the university level? This is my question, sir. Thank you.
I don't know whether any of the panelists can respond to this question. Lenesil?
I think the question was raised during the session, and I think Professor Ojukwu responded to it. Basically, you're not going to have a universal assessment. Each university has tried to design what constitutes the basis for assessment. And I think you even gave an example about even the time allotted for answers in the exam room. In some universities, it's 4 questions, answer in 2.5 hours, some 3 questions in 2 hours. In fact, in some jurisdictions, it's answer all questions. And then you have continuous assessment, so you find variation in the assessment methodology from university to university. I don't think that is where you want to make a law to say that there must be a universal, it will kill experimentation, it will kill development, And, so if there is a defective assessment process that has been noticed, it can call for improvement. But to universalize assessment process within the legal education will, even the lecturers and all that, maybe, like somebody said, is it a fact that Nigerian university lecturers mark their students down? Maybe that's the issue you want to address, as opposed to when you go to some other places where it's very easy. But I can tell you, in some jurisdictions, if you get a 70, it's not an A. Okay? So that's their own assessment criteria. So bottom line of it is that once you institute a methodology that is effective in producing the end product that we are talking about, we look at the assessment, processes in each university. If there is a defect, and that's where the Nigerian Association of Law Teachers can come in, raise this kind of, okay, what's the assessment process in each of the universities? What are the merits? What are the demerits? How do we improve on it? How do we go on to achieve an international best practice standard? So if you put out an international best practice standard, let's all aspire to it. I think that's what you can do to formulate a guide that can be what every university will aspire to. But putting this in the legislation would defeat that objective, because by the time you reach that which you put in the legislation, when there is improvement, you have to go back to legislation to do it again. I think bottom line is to look for an assessment that effectively, give the what you call the grade that the student deserves, as opposed to some where a lecturer may not mark a script for 3 months, and then they say you should submit tomorrow, and it sits down, this one, without even giving the student the fair hearing. And then an assessment that is fully loaded on one exam is also, a bit harsh. So if, for instance, during the course of the session, you have, put it in models where the student gets continuous assessment, and even before he gets into the exam room, 50% of it is gone. So that can be said to be fair. But to say you want to prescribe by law a universal assessment for university legal education in Nigeria may not be the approach to go. Thank you.
Yeah. Can I come in? Can I come in quickly? Can I come in quickly?
Another question, okay.
Yeah, I just wanted to the moderator come in quickly on this. I think, yes, it may be difficult, and it is not really what we should be aspiring to have a universal assessment. But then the key question on what should be at the core
on the already existing protocol.
On the core of it.
My name is Michael Arinze, the National President of Law Students Association of Nigeria, and I'm standing here this evening to contribute on the discussion that affects us as law students in Nigeria. From yesterday, we have been having an insightful session about the legal education so far, and I must commend the leadership of the Nigerian Bar Association for this opportunity given to us, because I believe we are the beneficiaries of this whole session. So I thank the leadership of the MBA and Alfred Babalola University for this wonderful opportunity to place the study of law in the international map in Nigeria. I want to preliminarily comment that the standard of legal education in Nigeria, as we have it now, is a compromise of our future in this country. Because when we discuss legal education, there is a temptation that we just talk about legal education without bringing into focus the fact that legal education has to also do with what? The legal system, and in fact, the whole society. So we cannot divorce legal education from the level of justice dispensation in our country. So this particular summit is a one that affects the whole Nigerian society. I have been opportune to attend some competitions that has an international outlook, and I will see my colleagues from other jurisdictions arguing on some aspects of law which I have not heard in Nigeria. And these are people that we should compete favorably with. So our legal education is fundamentally faulted. And within the course of preparing for this particular session, I had conducted a kind of survey among law students nationwide, and majority of the opinions of the law students nationwide, most of the challenges they distill. The number one is the anachronistic syllabus and curriculum that are being taught. Personally, I had attended classes in courses like tort, courses like contract, where I see some historical antecedents which has no practical reality in this present world. So most of those things we are taught in class these days cannot be able to equip us to face the challenges of this century. So apart from the anachronistic syllabus and curriculum, we also have the level of assessment where you are assessed with the level of your memorization. You are expected to cram the sales of goods and reproduce it to the lecturer. And when you don't do that, that is already a mark that will be given to you in a below average setting. Another thing that was distilled by law students across the Federation is the problem of technological advancements. This century has, of course, gone ahead, like it has gone very far in technological advancement. And in fact, with the complexities of this century, law students are required to be persons who are technologically savvy. They should be persons who are who knows the onions, the rubrics of technology in the application of what they are even taught in the class. Well, it's quite unfortunate that in very few institutions or faculties of law in Nigeria, we only have very few of faculties of law that, in fact, put technology advancement as part of the curriculum to teach law students. Then lastly is the poor infrastructure and condition of studies. Some law students in Nigeria, most of them study under hot weathers. Some of them don't even have good relationship with maybe the management, and the management cannot procure some of these basic needs for them. And it in turn affects their studies, because if I'm under a place that is not with a condition and I'm learning some principles of jurisprudence or evidence law, I find it difficult to be able to get what is being taught. So, but we understand that this particular summit is a kind of a revolutionary point in the history of our educational summit, educational history in Nigeria. And that is why
thank you. Your teachers are waiting for you and you've been talking. Thank you very much. If you've been here since yesterday, the 3 or 4 issues which you raised, I agree with you, they're all germane, but there are also the same issues that have been raised by speakers, and suggestions have been made, and way forward have been proffered. But I agree with all the points you have made regarding infrastructure, facilities, modern methods, and so on. But it also falls into exactly what has already been discussed here between yesterday and today. So thank you very much. Professor Fagbohun wants to respond to the first question that was answered from Zoom. Please, let's link up with Professor Fagbohun on Zoom.
And me too.
The moderator, thank you very much. Can you hear me?
Yes, I can.
Okay.
Yeah, maybe we're on Zoom.
I just want to add something to what Professor Yewuesi mentioned in terms of assessment. One of the things that we need to be interested in is...
Are we getting it?
Can you hear? Am I still on?
I think... Okay, well, I think Prof has disconnected. I would, at this point, round up the session.
It's on.
I would rather close the session by extending our gratitude to Professor Fagbohun, who is from over there. I think he spoke from Lagos. Professor Ngozi Ezelo, both also through Zoom, who made their presentations. And here with us, Professor Oyo, the Honorable Attorney General of Oyo State, who has been here with us throughout today. Thank you for your very valuable contribution. Professor Momodu Kasim, who is an oracle, an ancestor in this profession, who has still preferred to continue to render assistance and support for the progress and for the future of this profession for the benefit of generations yet unborn. We really appreciate all your services, sir. Mr. Tobina Erojikwe, I hope I got it right. Thank you, sir, for all the good work you're doing in the Institute. Some of us follow very quietly the developments there, and we'll continue to contribute anyhow you expect us to see that our system of continuing legal education continues to improve. And then, of course, I noticed that in some other countries, they give ratings and scores. I hope very soon we're going to begin to have some of those ratings and scores for persons who participate in your trainings. Okay, thank you. So we're most grateful, sir. Mr. President, maybe at this point, I will invite Mr. President for his closing remarks for the session. Thank you very much.
Thank you, Honorable the Attorney General of Nasarawa State and our moderator. These are not quite closing remarks. I know time is fast spent. Firstly, before I go to what I actually came up for, you were just speaking to our Chairman Governing Council of the ICLE, and you just promised to do anything that you can to enable the Institute. I know exactly what you can do for us, sir. We are setting up our training faculty, and we are going state by state, offering training to our lawyers in public service, procurement, PPPs. They serve in this country, the lawyers in public service, as you know, sir, they serve the most important clients. This is a government-driven economy, and those lawyers need certain skills before we begin to outsource to outside counsel. I know my friends, my colleagues will not like what I'm saying, but really, they're the first line of defense.
I went to, well, actually, we are in Ado-Ekiti, and I was here a while ago, and I visited the ministry, and your colleague, who, by the way, apologizes because he's out of the country, he would have been here, Wale Fakonda SAN. They have what they call an academy in there. And I said, this should be across the country because our in-house, our lawyers in public service, those in the MOJ, those in the MDAs, they carry out such an important function. And the MBA is willing, able to help in training them through our ICLE. But this will not be pro bono. I just thought I should let you know, sir.
No problem, sir. I agree with you 100%, Mr. President. And I think encountering this challenge for the last 4 or 5 years I've been AG, I recently had to write a handbook for lawyers in public service. I left in a hurry. I would have come with quite a number, but I'll send a copy to you.
Please,
but I agree with you 100%. Lawyers in public service are the first line of defense, are the most critical, really. And the service they render goes a long way in determining stability of government.
Yeah.
And of course, government is everything. It's machinery.
Continuing legal education for them is critical to handle the responsibilities that they have at the moment.
Who hosts it, sir?
The Honorable Attorney General for your state did not quite make a promise, but I've extracted the promise from him also that the ICLE would.
We've been talking. The fact is that we are even ahead. We are already engaged in continuous education.
Thank you, Lelesu.
And invested a lot of virtual and all that.
Yeah.
So
excellent. Yeah. Thank you very much. Now, ladies and gentlemen, we're almost done. I promise you. The reason why I came up, this is something I had purposed to do at the opening ceremony today. I had asked to be reminded there was so much going on this morning, and it escaped me. because the wrap-up session is, the closing remarks is not going to be from me. Professor Lawi, Senior Advocate of Nigeria, I think he has everything that we have. He has the wrap-up. He will come up stage after this session is disassembled. So, but the reason I'm here, this took a lot of planning, from conceptualization to right now. Legal Education Committee was set up, Planning Committee was set up, and man proposes, but God disposes. At the point where we started this journey, there is one of us who was with us, but is no longer with us. Which goes to show you that we are not in control. My friend and my brother, Anu Esho, I am sure when we put all this together, he thought he would be here with us today. But Anu is not here. We lost Anu on the 29th of October, 2021. He was a member of the Legal Education Committee. He was such a supporter. He was such a great supporter. Quiet, self-effacing, unobtrusive, but very effective. Supporter of the cause, and he was concerned about the state of our profession. And from the sidelines, he kept on. And I said, no, I'm going to pull you. You will come in and Anu, you will join Legal Education Committee. And he joined, and he was very, 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 very effective in his support. However, the good God that we serve, Lord God Almighty, thought it best to call him home when he did. And we cannot question God. I wish I had done this in the morning, but it's better late than never. Can we rise, please, for a minute's silence in memory and in honor of the memory of our friend and our brother, Anu Akpo Esho. May his soul rest peacefully in the bosom of our Lord Almighty. Amen. Thank you, Mr. Moderator.
Thank you very much, Mr. President. I will call on Professor Damilola for the wrap-up session. Okay, sure. So, okay, sure. Thank you very much. I will always be ready, happy to accept. Thank you, sir. I think that marks the end of this session. Thank you, everybody.
Gentlemen, may I please welcome the Mr. Frank Briggs, the third Vice President of the Nigerian Bar Association, to present the gifts to our very erudite discussants and presenters.
Honorable DAG, on behalf of the President and our dear association, I thank you for your service. Thank you. Our Prof and Father. Prof, in spite of all the years, I told you not too long ago that you seem to be shedding the years rather than adding them. Thank you for your service to the bar, your continuous service to the bar. Thank you very much. I'll save to be for last. Honorable the AG, thank you for your service to the bar. On behalf of the president and the association, we say a big thank you for your sacrifice. No. And Chairman Governing Council, my brother and friend, thank you for your great work. We appreciate everything. All the best on behalf of the president and our great association. Thank you. All the best. And I suppose the one for theirs will be sent to them. No, I mean the two online.
Well, it's been a wonderful summit. I'm sure you will all agree with me. We've had 2 days of very, very insightful, power-packed, and very eye-opening discussion about the current state of legal education in Nigeria and the future that we seek. Started off yesterday with a debate, a very rich one, I would say, on the current state of the Nigerian law school. Should we continue the way it is, or should it be unbundled? Our committee gained a lot of insights from the discussions by the panel. And then, of course, we had wonderful contributions from all of us, including the teacher, Professor Ojukwu, SAN. And of course, that set the tone for today. It's been a wonderful session today. And it's dinner time, and so I wouldn't go through the rigors of summarizing session by session what we have done today. But of course, it is crystal clear from the presentations that we all seem to agree that the state of legal education in Nigeria needs an urgent reform to keep it in pace with ongoing changes and transformation in the global market. That seems to be the consensus from each of the sessions. And the sessions were so beautiful because they talked about the various areas that need reforms. Reforms cutting across curricula, reforms of what we teach, how we teach it. We had a session in the afternoon on the need for much more practical approach to teaching. We had discussions on how to ensure that we not only focus on public law, but also focus on entrepreneurship, entrepreneurial law, and the likes. And it seems that our task as the MBA Legal Education Committee is very clear. Almost all of the speakers that spoke today asked one simple question: where do you want to go from here? Is this going to be the same situation in which we discuss, we feel good, and then we leave, and then nothing happens. I've had preliminary discussions with our able NBA president, Mr. Olumide Akpata, and as he has assured us all, this will not be one of those, nothing is going to happen. We are going to take the discussions forward. We are going to immediately review all that has been said at the NBA Legal Education Committee and set in motion plans for implementation. So, and I was telling some of my committee members that it seems after today's summit, our real work is just about to start, which is the process of collating everything that has been said, including the last session. Very, very wonderful, very beautiful. And then we'll start the implementation process. I want that music to play very soon, so I wouldn't stand in the way, but I must say how proud and delighted we are to have been able to actualize this summit. I want to say a special thank you to the NBA president, again, for believing in us, for keeping to his words, for ensuring that the NBA Legal Education Summit happened against all odds. So thank you very much, Mr. President. I also want to appreciate again our wonderful host, Afe Babalola University, under our able Vice Chancellor, Professor Smaranda Olarinde, for doing everything possible to ensure that we've had a wonderful stay, a remarkable experience here. We also thank the students of Abuad who have all served as ushers and have been on the ground providing wonderful service to us. We appreciate you. We love you. And of course, we thank the founder and chancellor for his support for the entire process, for being a constant voice in the call for reform of legal education. I must not stop without saying another word of thank you to the local organizing committee. They have worked tirelessly, sleepless nights, I must say, to ensure that this summit that is just about to end has happened the way it has happened. Of course, the chairman or the chairperson of the local organizing committee, Oludayo Olorunfemi, please stand up for recognition. Thank you very much. Thank you for all that you do. Thank you so much. Of course, the co-chairman, Dr. Bamidele, if you are here, please stand up for recognition. Ooh. Wonderful. Thank you. And of course, our secretary, Mr. Ayi Ekpeyong Ima. Please, a round of applause for him. He has worked tirelessly. Thank you. And of course, last but not the least, the general coordinator of each and every session, Mr. Tolulope Aderemi. Please stand up for recognition. A round of applause for him. Thank you. We appreciate all that you do and all that you've done. Thank you for your service. And I pray that you would always look back at this summit and say confidently that you were part of the process of change. We've done the hard work. We've had very insightful talk. Now it's time to relax, put on the dancing shoes if possible, and show us those academic styled dancing. I look forward. Thank you so much. God bless you all, and I wish you safe journey back to your destination. Thank you so much.